Hello friends, in the series on income tax cases, today we will discuss a very important case on section 271 DA penalty which is being levied on the assessee for the violation of section 269 ST. Section 269 ST broadly says that if an assessee receives cash exceeding rupees 2 lakh in respect of a single transaction, then penalty can be levied for the amount which has been received in cash by the assessee. The issue before Chennai ITAT A bench was that if the assessee receives some amount which is very insignificant to the total sale value of the assessee, and if the violation of section 269 ST is in very proximate to the amendment made in section 269 ST or with the introduction of section 269 ST, so whether these factors can be the reasonable cause for the escapement of this penalty. This issue has been decided by Chennai ITAT A bench in the case of AVR Swarna Mahal Jewellery Limited versus Deputy Commissioner of Income Tax, and this case is reported in 136 ITR Tribunal Short Notes 21. The date of the judgment is 16th March 2026. The present case relates to the assessment year 1819, which is very proximate with the introduction of section 269 ST, which was introduced with effect from 1st April 2017. Section 269 ST broadly says that the assessee cannot receive an amount exceeding rupees 2 lakh in cash for a single transaction, and section 271 DA says that if the assessee makes a violation of section 269 ST, then the penalty of the same amount can be levied on the assessee. In the present case, the assessee has received cash from two customers for the sale of jewellery for an amount exceeding rupees 2 lakh. When the assessment was going on, the assessing officer noticed these two transactions and the assessee was show-caused why the penalty under section 271 DA should not be levied on the assessee. The assessee submitted its submission. The assessee said that the staff which was sitting at the counter was not in the knowledge of the amended law, and the volume of the transaction is only 0.004% of the total sale value, and it was the submission of the assessee that the assessee has produced the address, the phone numbers and the permanent account number of the purchasers who have given the cash to the assessee. But the assessing officer said that the explanation of the assessee does not come in the ambit of reasonable cause for the violation of section 269 ST, so levied the penalty. The CIT appeal confirmed the order of the assessing officer. When the matter was before the tribunal said that in the present case, the cash counter staff has received the cash without knowing the amended law. The breach of section 269 ST is very proximate to the amendment or to the introduction of section 269 ST, and since the volume of the transaction is very insignificant, that is 0.004% of the total transaction, so in that case the penalty cannot be levied on the assessee for technical and venial breach due to bona fide ignorance of amended enactment with effect from 1st April 2017. The tribunal said that in the present case, moreover, the assessee has given the permanent account number, the address and the mobile number of the purchasers who have given the cash to the assessee, so the identity of the purchasers is also established. So the tribunal deleted the penalty which was levied by the assessing officer and which was confirmed by the CIT appeal. Friends, the moral of the case is that section 269 ST is to be taken very seriously, because if during the assessment the assessing officer comes to know that the assessee has received cash in violation of section 269 ST, there may be the cases where there is no tax on the assessee, but the penalty is very heavy under section 271 DA. So the section 269 ST violation is very heavy in the terms of monetary value or in terms of fiscal penalty. At the end of this video, once again I am repeating the name of the case. The name of the case is AVR Swan Mahal Jewellery Limited versus Deputy Commissioner of Income Tax, and this case is reported in 136 ITR Tribunal, short notes 21, and the date of the judgment is 16th March 2026. Thank you, friends.